On June 21, 2010, in a 6-3 decision, the Supreme Court upheld the constitutionality of the Material Support of Terrorism statute. Chief Justice Roberts held that providing material support to a designated foreign terrorist organization, even seemingly benign support, bolsters the terrorist activities of that organization, and that teaching nonviolent mediation could be used by terrorist groups to lure opponents into complacency. The Material Support Law was passed in 1996 during the Clinton administration as a response to international acts of terrorism. According to the statute, material support was initially defined as lodging, financial securities, monies, training, weapons, etc. It was punishable by up to 10 years in federal prison. Following the September 11th attacks, and in conjunction with the Patriot Act, the Bush administration strengthened and expanded the Material Support Law. The current definition of material support now includes tangible and intangible property and expert advice or assistance, and can result in a maximum 15-year prison sentence. Accordingly, material support is interpreted by the Supreme Court equates to monies given toward charity or humanitarian aid, advice on seeking peaceful resolutions to conflicts, assistance in establishing or promoting democracy, such as registering individuals to vote, and teaching basic life or language skills. Two specific examples. Should one travel to Lebanon, exercise caution. Donating to a mosque, or even to the sheikh of a mosque who has been designated as having terrorist ties by the State Department, can violate this law. Additionally, should one find themselves in Palestine, encouraging peaceful resolution to any individual deemed to be affiliated with a terrorist organization by the State Department can violate this law. It is anticipated that under its current interpretation, the Material Support Law will have far-reaching consequences. It will chill charitable contributions and humanitarian aid, will halt peace talks, negotiations, and efforts towards democratic progress, and could result in an increased reliance on violence. First, and perhaps most importantly, obey this law. Jurisdictionally, it can be enforced both here and abroad, and it is important to remember that it is the State Department's designation of an organization as terroristic in nature, such as Hamas, Hezbollah, or the PFLP, that triggers this law. The Roberts Court has stated that knowingly providing material support means merely that the donor knew about the organization's connection to terrorism, and does not require proof that the donor had specific intent to support the group's illegal activities. The Supreme Court has also failed to distinguish between independent advocacy and support, meaning that generalized advice, possibly without a directed audience, on using peaceful tactics could be interpreted as a violation of the Material Support Act. Finally, contact your representatives. Let them know that this will have far-reaching implications into the Muslim community and is a violation of your First Amendment rights of freedom of speech and of association.